just this time with us over your lunch hours. We know everyone is busy and we're going to try and be as efficient as possible. We have done introductions in the past. I think Judge Semper, maybe is this your first meeting with us?
It is. You may have just received an email from Judge Gill here in Eugene Municipal Court, and I will be from now on taking over for him in this group, which I'm excited to do. And I know a lot of you already, but.
Good. Well, welcome. In the interest of time, we'll just go forward without introductions at this meeting, beyond just welcoming Judge Semper. We have on our agenda, the second item is the items that are carried over from our last meeting. And one of those is the jurisdiction proposal. What I'd like to do is to call that to your attention. This is a proposal that Jim and his group have offered up. You have it in a Microsoft Word document. Hopefully you've had a chance to look at it. I know Judge Britton sent around an email saying that this is going to also be given the attention by some people who've been working in these ORSs for a long time. And Judge Britton, you've requested that we circle back later to take into account any feedback they may have. But I did want Jim to give you the opportunity to ask for any feedback, and if anyone has anything on the jurisdiction proposal, to just take a few minutes now and share that. Otherwise, we do have the understanding that we will be circling back at Judge Britton's request. Anything we should know in particular, Jim?
Part of what originally drove me to rewrite or to propose rewriting the statute is that the existing statute refers to jurisdiction otherwise conferred by law, but doesn't tell us where that will be found. And I was unable to find any other statute that conferred jurisdiction, at least not until 2 nights ago. 2 nights ago, I was looking at ORS chapter 156, and there's a little statute at the very end of that chapter that says that justice courts have jurisdiction over certain offenses that have to do with animal neglect, mistreatment, and so on. And if you go and look at those statutes, under some circumstances, those can be prosecuted as Class C felonies. So apparently, there is that one statute that that impliedly confers jurisdiction on justice courts to adjudicate certain felonies, but otherwise, I'm not aware of any other statute that confers jurisdiction on justice courts, at least as far as subject matter jurisdiction. There was other language in the, yeah.
We do have jurisdiction over warrants as well, and within our county.
Warrants for felonies, you mean?
Sure, anything. Now, I don't get them because the DA's office would rather have a circuit court judge sign them, but we do have that. We do have the authority. I get them when I get them. It tends to be for code enforcement purposes, but
okay.
But we do have warrant. We do have warrant jurisdiction. I'm not troubled. I'm troubled that this is we're messing with statutes that don't have anything to do directly with appeals, and I'm just concerned about some of that. And this is one of those areas. That's one example I can think of off the top of my head. There may be others.
In Tillamook County, the Justice of the Peace has been asked to be in the rotation for warrants, circuit court warrant rotation. Just to add to what Judge Cross said.
Okay, and that's fine. That perhaps the solution then is to make clear in this statute that the justice court jurisdiction includes issuing warrants. My concern is that because most people who appear in justice and municipal courts are self-represented, this statute is not very helpful in telling self-represented people. Indeed, I'm a lawyer and I've read it many times, and didn't know to what it referred. So it was the sheer ambiguity of the statute that bothered me. The reason that we embarked upon modifying this statute as part of a work group that is focused primarily on appeals is that the correct appellate procedure depends upon whether the court is exercising jurisdiction in violation or misdemeanor cases on the one hand, or civil cases in the other. And indeed, and then also, of course, it depends upon whether you have chosen to become a court of record. We certainly don't need to amend this statute in order to otherwise carry out the goals of the work group. But the sheer ambiguity of the statute and reference, and also one of the other things I wanted to mention is that I think the statute impliedly refers to statutes to deal with venue, because there is a statute that says that a justice court can have jurisdiction if the offense occurred a certain number of miles away, even if it's in another county, or if it's a multi-element crime, if one of the elements was committed in that justice court. So the statute that on its face purports to deal with jurisdiction also implicates venue issues. And I don't think that's obvious to the first reading of the statute, or even multiple readings of the statute. So as I said, we don't need to amend this statute, and we certainly may choose not to do so. My own preference would be to amend it so that it's clearer, but we certainly don't have to do that.
Yeah, I think we're focusing on appeals, but we do have an objective of trying to make these statutes work together and to be clear and easy for people, especially people not trained in the law, to read. And the reason we need to understand how the jurisdiction statute works, I think what you're saying, Jim, is among other things, we need to know what types of cases are going to be appealed. And we have to understand which violations, which misdemeanors, and apparently also possibly which felonies for these animal abuse felonies might be coming to the circuit court. Any other feedback just at this point for Jim on the jurisdiction proposal?
Yeah, Tony Rasta here, Justice. And you know, this is my second meeting, and I don't know as much as you folks do about what you do in your courts, and I see Judge Zemper's here. I'm glad that she's here. I did a lot of work in municipal court in Eugene for years and years, and it seems to me, just from my trying to get an overview here, a lot of the courts handle way different. They handle their cases completely differently, different sorts of cases. Eugene handles many misdemeanors, jury trials, and I've done a lot of them, and they are not much different from when I started when there was district court before the circuit court took over that. So it really is it needs to be considered of each of these courts. I don't see too many civil cases in Eugene Municipal Court. Lots of traffic violations, thousands of criminal misdemeanors that are trials. And one of the questions that was asked is, are the appeals real trials? Yes. I mean, they're trials de novo. We'll have lots of jury trials. Judge Zemper's presided over lots of them and prosecuted cases in them as well. So I think it's important to get a good overview factually of the varied kind of caseloads that these different courts have. I am concerned and I don't know if it's Justice Cross or Mr. Cross, but to expand the jurisdictional discussion, some of these statutes, they're a little hard to navigate, but they've worked pretty well for over 100 years. And they came from you know, very early in Oregon's history, I think. And I'd be cautious to tinker with some of those without thinking about unintended results. Clarity is great, and there hasn't been a lot of clarity with these statutes, but it might be another task altogether. That's just my comment.
Yeah. Other thoughts on the jurisdiction proposal before we move to our second item?
Justice, this is Melissa Franz from the City Prosecutor's Office. So subsection 2, and this may have been addressed in an email and maybe I missed it, but 51.050 subsection 2 addresses the removal of the cases to circuit court if they wanted to do that. Is this going to be addressed in a different section?
The subsection 2 of the working draft and
The current subsection 2 of the proposed repeal of statute ORS 551.050.
Okay, section. So I have a section 1 and then subs 1 and 2, and then sections with question marks for municipal court.
Sorry, the current ORS 51.050 subsection 2
Okay,
addresses the ability of a defendant to remove the case. So instead of doing trial at the court, they have the ability to remove it over to circuit court immediately. Is that being addressed or will be replaced in a different subsection?
so
Of
we
the new
talked
draft.
about transfer, so that's the term I think that's used in the justice court statutes, and we decided that transfer, that is our section 2 of the working draft, and we were leaving transfer. I'll flip back here. As it was, there was a question about whether we would change transfer to include anything more than it did, and the decision was no. So that was for justice courts, and so there's a parallel provision for municipal courts, is what you're saying, and which is removal. And we don't have that in this proposed repeal of 51.050. Jim, any reaction to that? Any thoughts on that? I don't imagine we would want to change anything on what's removable.
The draft bill at section 5, section 5. The draft bill does, section 5 of working draft number 3 addresses transfers. And basically what the section 5 does is restate existing law, except as drafted, it purported to include violations. But at our last work group meeting, we decided to strike the violations from it. Once we do that, the only thing that this rewriting of the statute adds is it makes clear that the circuit court's disposition of the transferred case can be appealed like any other criminal case can. The issue also arose at their last meeting is why are we dealing with transfers to circuit court in a bill that deals with appeals, because a transfer is not an appeal, it's actual removal of the case from one court to the other. The answer is that we propose to delete ORS 51050 in its entirety, and so the bill has to reenact subsection 2. Even if we don't make any changes to it, we have to do something with it. The other option, I guess, would be not to repeal ORS 51050 in its entirety, but merely amend it to delete everything except the existing subsection 2.
That makes sense. Would it be okay if on that Word document that we have regarding
A jurisdiction.
regarding jurisdiction, if there's a way to note that subsection 2 it will be addressed in section 5 and whatever section it will be for the municipal courts. I think you've done that on previous bill drafts, Jim, or notations. I appreciate it.
Okay.
Thank you.
All right, I'll just pause before moving on from the proposal on jurisdiction. All right, the second thing we want to just circle back to from our last meeting is to be on the agenda, which concerns public records, is section 4 of the working draft. And Jessica Menifee had done the research, which she shared with us last time, about the sentence at the end of the current statute. The statute says such records, so case records of a justice court, are public writings. And Jessica, you determined that the public writings was probably a reference to public records. Is that correct?
Sorry, I was just trying to get my unmuted. There, I mean, there's a little more nuance there. The terminology has changed over the years, but the only possible remaining meaning of public writing is really public record as we use in currently in chapter 192. So it would make total sense to just change that to public records because that is the current terminology used.
So could we get people's reactions on changing that last sentence to such case records are public records for the purposes of, and then Jessica, would we say chapter 192?
Right, and there's a specific series within there. It's like ORS 192.311.2.4 something. Off the top of my head, I don't have it, but it would be replaced by a reference to that, which is what we use throughout the statutes.
Okay. How does that sound to everyone?
Tony Rosta here. I don't know if that has it been considered whether that bringing that term into chapter 192 might impose additional administrative requirements on courts with respect to keeping public records. You know, I mean, it is a different word, and I agree that it's a little confusing, but does it suddenly take these smaller courts into a whole realm of now having to have administrators to handle this sort of stuff?
No question.
Well, we already do. I mean, we get hundreds of public records requests on our case files now. We already have systems in place to respond to those. So I'm not sure it'll create an additional responsibility that isn't already there.
Right, any public body is already subject to chapter 192, the retention requirements, the disclosure requirements, all of that. So this is not creating a new responsibility. This is just clarifying that what those documents actually are. And I'm happy to discuss more of the background either here or offline, or if people want more information about that.
And Justice, I'm trying to figure out, because I didn't find the right section for a couple minutes there, and I apologize. You had read proposed amended language.
Yeah.
Can I hear that one more time? I apologize.
So it would be the last sentence of section 4 would
Yep.
Such case records are public records for the purposes of, and then we would insert the ORS series.
Right, and that's 192.311 to 192.478.
And I had written on my copy of the working draft, and I can't remember if somebody said this or if I said this, or I don't know. But the language, to complete that sentence would be, and subject to an applicable public records request. I don't know if that's necessary or just being redundant. Jim probably could tell me that.
Yeah, I think it would be redundant because by referring to the appropriate subsections of ORS chapter 192, we have incorporated the opportunity to make public records requests.
All right. Sounds good to me then.
Okay, in subsection 4, I have a question about why, or if there's been a firm decision to turn over the records to the clerk of the circuit court rather than the clerk in the county clerk. Because you're going to have an issue of accounts receivable
So I think the language for section 4 about turning over the records in the event of a closure is from current 51-130. When any justice court is abolished, the docket and files of that court shall be turned over to the clerk of the circuit court for the county in which the justice court was located. So I don't think we meant to change anything there. But please let me know if I'm missing something.
So Judge Brisbane, you think we should change that to reflect where the financial aspect should be maintained or transferred to?
Probably, it's, so
So
in
the
Lane,
the record should go to the circuit court, but the financials should go to the county.
right. So in the past few years, there were 3 justice courts in Lane County. 2 closed, 1 remained open. The one that remained open took over the files of the other 2. And I think if we inquired of what happened there, they wanted to keep 1 court open. It's a very rural court in Florence. I don't know how much it's used, but they probably kept it open to assure that the accounts receivable stayed with the county. That might have been one of the big decision-making factors.
Lindsay?
I have a little bit of information about, I think, that specific situation from our trial court administrator in Lane County. And she said that, explained the same thing, that the county maintained the records and continued collections of fines when those justice courts were abolished. And she explained that that was a better process than the case going to the circuit court, just because there's issues with the space for paper files and also the electronic systems that courts might have. And I don't know if there's a variety of electronic systems that justice courts or muni courts might have, but that could be an issue if the circuit court is to assume electronic files and how those would transfer. So I'm not sure if there's many other examples of this happening in recent times, and I have reached out and I'll gather more information if we have them, but I do think there are some logistical issues with those files going to circuit courts.
And the answer to your question about the software, municipal and justice courts do not have a uniform system such as the circuit courts do. We all have different systems. Many of us have the same systems. They're made, several major systems, but we're not uniform.
Is this something, Lindsay and Justice Brisbane, you can confer on and perhaps make a proposal about whether this current law should be modified in a way to cover closure of justice courts, especially when there remains a justice court in the county?
Sure, yeah. I'd be happy to share what information we have.
Justice Duncan, let me point out that we're talking about the term case records here. Case records is defined in section 3 of the bill, and that definition does not explicitly include financial records. It refers to the case register and the court file, the actual paper file, or the electronic file of documents. It's an interesting question whether the financial records of a case are subject to the definition of case record here. I mean, I can certainly understand a situation where if a justice court closes down, you might want to have the case register and the physical file transferred to the circuit court, but the financial records retained by the county. That certainly is one option. Or the better policy is to treat the financial records as part of the case record. But just on the face of it, all we're talking about here is the case records, not necessarily the accounting records.
And I don't know how they're kept, whether there's a separate financial, something that would be separate financial records. Our case record definition will include all the judgment orders. I would assume that it would include any receipts about monies paid, but maybe when Lindsay and Justice Brisbane think about this, we can bring your expertise about how these records are stored. And our purpose here, like Jim is pointing out, is we are just talking about what do we call these portions of the file that are going to have to be moved in the event of an appeal. So that's the purpose of this case record definition. And that's why we have that here. Okay. So let's go into working draft 3. This is section 9. Section 9 concerns the contents of an appeal. And here what I'd like to do is get a sense from both of our representatives of justice and municipal courts about how the notices of appeals work for you. I know from searching online that some courts have their own notices. And I don't know if it did not appear that there was a common form for justice or municipal courts across the state. I know, Lindsay, you have OJD experience with the development of notice or of forms. And Jim, you're familiar with the ORAPs that have a standard notice of appeal form. And then Paul and other folks are familiar with the notices of appeal from circuit courts to the Court of Appeals. So we have section 9. It's just collects the information. It's a list basically of contents that we've drawn from other statutes that govern notices of appeal. We'll talk about those contents, but I'm interested in hearing about how things work with respect to the notices of appeal, and if people have ideas, general ideas about improvements on this topic.
Judge Brisbane, do you want to share how your court helps facilitate the appeal paperwork? I believe it was either you or Judge Patnod was saying you all use the circuit court form.
I think one of the great outcomes from this committee would be to develop a statewide appeal form that everyone could use when appealing from justice to municipal courts. There's not a form available. And that's one of the main drawbacks of the system now, because there's not a uniform way to transfer a case. Not transfer, but move a case over for appeal.
Okay. That's certainly something that we can build into the statute.
And the simpler, the better.
Yeah.
You know, the one we use in my court, which I'm not saying is perfect, but it's one page. And the information is in fact, if they do it, most of the time if they do it, they come right to the counter and do it right after the trial when the disbelief in the ruling is still high. And they fill out, and the staff will fill out. It's just a template, punch in some things, and then the fees are on there as well. And it's but something standard and uniform but short and to the point would be, I think, a very good thing to have.
Would those of you who have forms in your courts be willing to just email them to Sandy, and then we can take a look at those, and then maybe there's one or two people who want to take the lead on synthesizing and synthesizing the forms that are used, cross-checking them against the rules of appellate procedure and the existing ORSs, and proposing a form. So anybody who wants to take a shot at that?
Sure, I'm happy to. Who sent it to who?
Send the examples to Sandy.
Sandy. Yep, you bet.
We have an email group of all the justices of the peace in Oregon, and I'd be happy to send an email and ask every judge to submit their form, every judge that has one to submit their form, and I could forward them on to Judge Cross, and he can
That'd be
Or
great.
or we could, yes, let's do that. We can get everybody's form and look at it.
Okay.
Justice Duncan, I agree that there should be a uniform form. And I think that can be done in either of two different ways. One, we can prescribe it by statute. The other is, and I may be sticking my neck out here, but the Judicial Department has a committee whose task it is to prepare forms for all kinds of cases, restraining orders, domestic license cases, FEDs, and so on. And I served as a member of that group for several years before I retired, and they do really, really good work. And what's good about that is that these people are very good at drafting forms that are usable by self-represented people. The downside is it often takes them a while to get the job done. But I'm throwing that out as an option that either we can prescribe it by statute or authorize the Judicial Department to prepare a form. The latter approach is helpful also because if there are any subsequent changes of the law that require changing the form of the notice, that committee can do that without a statutory change.
I saw both Melissa and Lindsay, who have experience with OJDM forms, smiling. So do either of you want to say to react?
I don't know. Is Holly still the forms gal?
Yeah.
Or JD? I'm sure she'd love this.
There is also kind of standard wording that we see in statutes when the state court administrator is tasked with creating a form for this kind of purpose. So I'd be happy to pull some examples of kind of the typical wording when it's an OJD task. I'm also curious, we talked a little bit about which court notices of appeal should be filed in. And I'm not sure if that's still an open question that this group is discussing, but that might be kind of part and parcel with this question of who is going to create them.
Take the lead on the form, sure. We are going to take that up. That is section 10, which is the filing and service of the notice of appeal. So you're absolutely right that wherever the notice is served, that may affect that may affect what we put in that will affect what we put in any standard form. So on this, why don't we collect the forms? Thank you, Justice Brisbane. We'll collect the forms, get them to Sandy directly or indirectly, get them to Sandy. We'll have those forms available for people to look at. If our form is really simple and we draft a statute that says the notice of appeal should, I think other statutes say things like should essentially be in this following format so that, you know, there's some flexibility that people can just create their own if they need to, or hopefully we would have something that would be a model, if not actually provided by OJD to all the courts, it would be a model that all the courts could follow. So if it looks simple enough, maybe we can put it in the statute. And hopefully our goal is to make it as simple as possible.
This is one instance where I think it'd be very helpful for those circuit courts who have been receiving notices of appeal prepared on forms furnished by the justice or municipal court, whether those circuit courts are happy with those forms or whether they would like to see changes made to them.
Lindsay, can you find that out for us? And I know
Yes.
in comments on the working draft a while back, there was a question about, there was an issue raised about whether the notices contained all the information that OJD wanted them to contain.
That's right. I think under the current process, though, the notices are filed in the justice court and then the whole record comes to the circuit court. So I'm not sure if there's an issue with what's in the notice at that point, if the whole record is going to the circuit court together. But I can definitely touch base with our trial court administrators and see if they have any thoughts on that.
Okay. Melissa. let's see.
Yeah,
I
I
think-
think
Go ahead.
one area that may be different is that circuit courts are almost all electronic now, and so one key piece of information circuit courts like to have is the email address of each of the litigants, if they have an email address, and that information probably is not in your typical municipal or justice court case file.
Melissa?
Thank you. And just for the group's awareness, just talking about the forms again, I think it would be really helpful just thinking down the line, you know, once we're out of this work group and the legislation happens 10 years from now, because these statutes are statewide statutes, OJD has a very robust way of following legislation that occurs, and they start getting the ball rolling for forms and everything to conform with statutes that pass over the years, that I know for especially smaller municipalities may not have the resources for. In my experience is, you know, once something happens at the legislature, OJD's administrative processes get the ball rolling on forms that need to conform with the statute. So thinking, you know, 10, 20 years down the road, if, you know, they want to amend these statutes again, having a statewide form that they could just say, hey, the statute changed. Now we need the form to conform to what happened at the legislative level. I think that would be super helpful for just municipalities and counties to have that, you know, maybe there's a listserv where we all get the forms and we can update them locally. I think that's just super helpful down the road.
Sounds like it will be. On the notices of appeal, the contents of the notice, I just want to flag an issue. So we're on section 9, there's a subsection 6, and it says identification of any recording or reporting. This is the issue we have talked about, where you can have a recording or reporting be part of the official court record. If it's an official part of the court record, it's already going to come to the appellate, to the circuit court. I suggest that we delete subsection 6. I don't think it's necessary, but would like people's thoughts on that. At risk of jumping in, hopefully not.
I'm
Sue?
trying to,
Okay,
because there's some confusing language in 105. Or
Yeah, so
potentially.
this would just like eliminate any, nothing in the notice of appeal would have to say anything about a recording, because if there was one and it was part of the record, it's going to come to the circuit court. So this just would eliminate a suggestion that's in this proposal, that we have the notice of appeal mention some sort of recording.
I suppose the only issue is where you have a recording made where not all parties have agreed under 105 subsection 4. They don't all agree to it being the official record of the proceeding, and there might be dispute about whether or not it's included then. Is there anything we need to address in that regard?
I think if it's not an official recording, then it's not part of the record that's going to come up. In the circuit court, perhaps the parties could agree, they could stipulate, like if the recording had an officer's testimony, perhaps they could stipulate that that recording could be used. But I don't think that there's any, I don't think that that possibility is something that needs to be captured in the contents of the notice of the appeal.
It is a trial de novo. It can certainly be used as an exhibit or some type of impeachment. And I think,
So if that's okay, we would just take 6 out. And the other thing I wanted to ask was about subsection 7. This concerns probation appeals, and this draft says in subsection 7, if the appeal is from a probation order or judgment, you have to identify a colorable claim for the basis for the appeal. That language, Jim, if I'm not mistaken, is intended to reflect what the requirement is for appeals from circuit courts to the Court of Appeals. And so my question is, do we need this designation of a colorable claim of error when the appeal to the circuit court is de novo?
Well, it probably depends upon whether we define appealable documents as including an order revoking probation or modifying probation. It comes into play when the judgment has been entered and the person has been placed on probation and the time period to appeal from the judgment has long since passed. And what's at issue is whether the trial court had properly revoked or modified a person's probation at some later time. I don't think it's clear under current law whether a defendant could even appeal from such an order. But if we agree that the defendant should be able to appeal from such an order, then that raises the question, certainly as to misdemeanors, whether those appeal rights should be the same as they are in an appeal from circuit court from an order revoking or modifying probation. And I'm just kind of hesitant to talk about this because I don't know whether it even ever happens, even though justice and municipal courts may have jurisdiction of misdemeanor cases, and they may even have a lot of them. Does it ever happen that the court modifies or revokes probation in a misdemeanor case?
Let's get Jimmy's got his hand up, and then let's get a response from the group about what probation decisions the courts make and current practices for appeals from those. Jimmy?
Sure. So I think there are sort of two questions here. The first is, should probation decisions be appealable? And then subsequently, what should happen when they are appealed? Like what new things should be redetermined and what things should be left the same way? I actually have a bunch of concerns about how the current draft doesn't really deal with some of those questions, but I think those questions arise more in section 16 through 18 and maybe section 13, but not here. I think the colorable claim, though, doesn't really have a role to play. That is, if there is going to be any appeal here, the review is going to be in the form of a de novo proceeding, whether that's a de novo probation revocation hearing or a de novo trial. And I'm not sure in any of those the concept of a colorable claim of error really has a role to play, right? When you're appealing from the circuit court to the Court of Appeals, particularly from like a probation revocation decision or guilty plea, the type of review you can get is very limited. And the purpose of the colorable claim is meant to sort of weed out cases where there's not really an issue that you can raise on appeal at all. You need to find some kind of legal error. It's not enough just to say, well, I wish I got a different sentence. But if we're allowing, for example, a de novo probation revocation hearing, just saying, well, I wish I could have got a new sentence might actually be perfectly fine because it's going to be a complete redetermination.
Right.
So it's possible that this question is sort of bound up with the question of, well, should you be able to appeal probation revocation? I'm sorry, I've got a train passing by. Should you be able to appeal probation revocation proceedings and what should happen in that appeal? And that's maybe a question that we're not going to get to until section 16. So we might need to table this, but I'll just sort of forewarn that I don't think the colorable claim idea has really a role to play in this type of appeal.
can certainly take up the what can be appealed in probation cases at all. When we get to that in this section, and obviously that will relate to, you can't appeal them, then this takes care of, then that takes care of this. If you can, then you would have to decide whether there's a colorable claim, but if it's a de novo probation hearing, it's not sure, it's not clear why we would be screening them for colorable claims.
And I'm persuaded that given that the scope of review is a de novo appeal, even if we make clear that a defendant can appeal from such a post-judgment order, they need not make this showing of colorable claim of error because the scope of review on appeal is de novo. I think we can strike that from this section.
Let's go ahead and plan to strike that. Seems like we don't need it with, regardless of what we do with probation appeals at all. So that is section 9, contents of the notice of appeal. We've got follow-up coming in with collection of forms, checking with the circuit courts to find out if they're getting the information they need. We're gonna delete 6 and 7. Anything else on section 9? Contents of the notice of appeal. Is there anyone particularly interested in developing a sample notice of appeal?
So I'd be willing to help with that.
Okay. Great. Okay. Filing fee, that's section 9A in our working draft, and all that we were pointing out here is we're trying to make the procedures clear to everyone. The current statutory scheme governing appeals from justice courts doesn't mention filing fees. There is a ORS that talks about them, and so Jim has circulated just yesterday, so you haven't really probably had a chance to, or just in advance of this meeting, have had a chance to look at a proposal regarding how we, within the explanation of appeals, talk about the filing fees. And so just want to call that document to your attention. It went out with the agenda. I also know that there were larger issues that people had about how the fees are collected and who can where waivers or deferrals should be filed. So just like the sense of the group about current practices and any suggestions for improvement. And I imagine people have ideas.
Well, I think the current practice in I think most justice courts anyway, is of course the notice of appeals filed in our court, and we then transferred to the circuit court. When a defendant files the notice of appeal, they must submit the circuit court fees with that. This issue comes up, for example, when you're in a county like my county, Washington County, where the circuit court adds on a trial fee on top of the $281 filing fee.
Okay.
So in my county, for example, a defendant has to submit $420 with the notice of appeal for the case to get sent over to the circuit court. If they need a waiver or deferment of that, they have to go to the circuit court to get it. But I would prefer that it just be that the $281 be the only fee that they've got. Obviously, I know that would probably require an amendment to the current ORS, which does give some leeway for trial fees to be added. And maybe just say change, except as provided in ORS 51. What it would be that they could do that trial fee, which we're simply excluding these from those types of trial fees. But in any event, I would suggest to be limited to $281 as the fee. We transfer the case over. And that, and then they have the jurisdiction over the case and they do the de novo appeal. Judge Brisbane, have I missed anything, Judge Brisbane?
No, that's it for that part.
Right. There's a different part with regard to if the verdict is still guilty, but
So, for your courts, if someone comes in and they're seeking a deferral or a waiver, do you say we can't move the case until we get your filing fee and maybe you'll get a refund? Or do you say, okay, we've got your notice of appeal, we're gonna accept this motion for a waiver, a request for a waiver, we'll forward that without a check over to the circuit court?
I sent them over to the circuit court to get the deferral or waiver. I mean, it's
Oh, so, okay, so they get the notice in your court, then they go over to the circuit court, get a deferral or waiver, come back to your court and then
Right.
submit the deferral or waiver with, okay.
right.
In some, well, the form's available online, so the person could get it online. But since it's circuit court's filing fee, they are the one making the decision about whether it should be deferred or waived. If it's deferred, then the defendant would pay whatever the payment plan is that's set up by circuit court to circuit court. But if it's waived, then that takes care of the filing fee issue. In our county, the court clerk in circuit court also lets us know if they've approved it or not. It happens almost immediately because the court clerks can handle those processes without getting a judge involved. So, it's a 10-minute drive to circuit court, but we accept the notice of appeal because it has a deadline, and we hold that until we find out what circuit court's decided about the filing fee. And then once that's decided, if there's a waiver, that takes care of it. We send the file over. If there's a deferral, they deal with circuit court. And if there's no waiver or deferral, then we take a money order or check and we have a courier service that goes between justice court, circuit court. We courier that over in a locked money bag to circuit court. But I know in some places, the local courts either drive the file to circuit court or mail it.
Okay.
We would like to be able to electronically file our files because we have electronic files, but circuit court's not in a position to take the file electronically yet. So we print out a paper copy of our electronic file and then courier that to circuit court.
Yeah, I don't know. I had an issue when I first became the justice of the peace here, where the circuit court's practice at that time was that the deadline, the 30-day deadline for filing the notice, that they had to receive it in the circuit court by the 30 days. And I said, no, they're filing the appeal in the justice court. At the justice court, the 30-day clock runs in the justice court. As long as they get the clock in here, the justice court, even if I send it to you 2 days later, and I prevailed upon them that was correct. And that issue is no longer an issue in this county. But I don't know if that's an issue in any other counties.
I don't think so. Circuit court will accept it if we send it over as the official record. I know it says we're supposed to do it in 10 days, but that's a pretty tight turnaround for big courts. Well, we have a high volume and we have a low number of employees. So that 10-day turnaround, we might have to ask our circuit court if they would waive that on, but that's a totally separate issue.
There's
Clarification. Can I ask a question? The motion to waive or defer fees, is that motion tendered to the justice court along with the notice of appeal, or do you direct the person to file the motion in circuit court?
File in circuit court.
Yep, I'm same.
So this is what's fascinating to me, is that the circuit court has to act on a motion for a non-existent case. There's no case in circuit court. There's not even anything tendered to the circuit court. All they have is a motion to waive or defer fees.
Well,
But
they'll
that's,
have,
I'm
that's,
wondering-
that's not that uncommon, Jim, knows in some areas, like, if somebody comes to file a small claim in my court, but they're seeking a waiver of the filing fee, I'm making a ruling on that motion without any case yet being in existence. For
See,
example,
what I was envisioning is that a person seeking to file notice of appeal, assuming we stick with the current system that the notice is filed with the justice or municipal court, is that they file the notice with you along with a check or money order for the amount of the filing fee or the motion to waive or defer. And the justice or municipal court sends the notice of appeal along with the money or the motion to circuit court. The circuit court then has something in front of it to which the motion to waive or defer fees relates to. Just as if the person had walked up to the circuit court counter and filed the notice of appeal and the motion to waive or defer fees, like any other civil court case. So I guess my question is, why are we treating filing fees differently than the motion to waive or defer fees? Can't those just be sent over to the circuit court at the same time?
okay, what happens if circuit court doesn't waive or defer and the file's already gone? You know, we're gonna be chasing people around. The file is already gonna be over there. It's filed with circuit court. Do they have to hear it even if the person doesn't follow through with paying the fee? We do put a case number on the defer. We have the defendant put the case caption and a case number on it. So circuit court does know that there's a case coming and we're in contact with them, because we don't just send a defendant over with the waiver and deferral form and have them bring it back. We get the official notification from circuit court about their decision. I mean, people do change paperwork and things like that, so we want to get it directly from circuit court. I mean, we work with circuit court on a lot of, it's not really an issue. We work cooperatively with circuit courts on many types of cases, and so we're in regular contact with the regular people that we work with over there in the civil division and criminal division.
so Lindsay, I read the statute, the entirety of that you sent out. I think that's helpful. It seems to me that would indicate that circuit courts are empowered to make rulings on waiver or deferral on potential cases that have not yet been filed, because until the court makes a ruling on that motion, they can't accept the filing. Am I reading that correctly?
No, I think that's right, but at least in those circumstances, the circuit court has something in front of it.
It's got
Petition
a
to
potential
dissolve
case.
marriage.
It's got a potential
civil
case in front of
action.
it, just like this is a potential case in front of it.
Paul, I see you have your hand up, Paul. Did you want to say something?
Well, in my mind, all of this begs the question, and maybe we're past this, but why is the notice of appeal filed in justice court and municipal court? I mean, and I'm coming at this from a perspective of someone who only practices in, the Oregon appellate courts. But there we filed a notice of appeal in the Court of Appeals, and then the Court of Appeals requests the record. I mean, it used to actually have to request the record. Now it's all transferred electronically for the most part, I think. But I mean, it's intuitively, it makes more sense to file the notice of appeal in the court that is going to handle the appeal. That court at the same time can rule on a deferral motion or a waiver. And once they have accepted probably just the 1-page notice of appeal or 2-page, whatever it is, can then say to the justice court or the municipal court, okay, now send your record over to us. Again, I don't practice in this area, but I guess I'm wondering what the rationale is for filing it in the justice court.
Right, I think Lindsay, in your written comments, you had raised that something perhaps along those lines. And I don't know if you have a circuit court perspective about whether it would be easy for, if the notice is filed in the circuit court, then it can also get the request for a waiver or a deferral and rule on those and process the filing fees.
I do think that perhaps that would be maybe not as procedurally complicated as all of the solutions we're trying to come up with. I really do think from our perspective that really just clarity in the statutes, because as we talk about, you know, what different justice courts are doing, I think there is just a wide variety of practices across the state. So to the extent that we could just get some clarity, and then obviously minimizing the back and forth, but clarity in the statute so that the folks that are actually filing these notices of appeals and tendering the fees, you know which court they're going to and which court is going to rule on them from our perspective would just be the best thing to do in this legislation.
I will tell you that while I don't disagree with Paul that it makes more sense to do it in that logical way, and the problem is almost all of these folks are pro se, and they're going to get more hand-holding and better service to get through this in my court than they will in a circuit court. And that, I think, is really what it boils down to. And then we always have to keep that in mind when we're dealing with justice courts and municipal courts and these statutes, that sometimes what we're really doing is trying to make it as helpful to the pro se litigant as possible.
And I'm just mindful of the time here. We have run over, I think, because today it's just a 1 hour meeting. I think this is an important issue for us all to think about. Would it be what kind of helpful system can we, what kind of changes, if any, do we need to make to achieve what Lindsay's saying, like clarity, and then perhaps like what Paul is saying, efficiency? Could we have it so that someone comes in and Dan, they have the service of your Judge Cross, they have the service of your court where you say, here's this notice of appeal form, and you need to go from this court either by mail or by person, and you complete this form and this waiver form, which the circuit courts have provided to us because they have to be the ones who rule on these, and take it over there, and they will let us know when to send the file. So maybe we can think about that. That may make things more, just think about that, think about how that process would work. Krista, there's a doodle poll that went out, and you want to just quickly touch base about next meetings?
So I think 8 people filled out the doodle poll, and we've got a variety of potential dates out there, but I think the bigger question at this point is how often people feel like they can commit to meeting, and what folks want to do going forward here. And I don't know, Justice Duncan, do you want me to go ahead and address that?
Mm-hmm.
So I think we had been hoping to push this forward in a way that would allow us to get a bill into this coming short session. At the pace we're going, it's looking like it's going to be a pretty steep ask at this point. And so we've had some feedback that it's difficult for people to meet on a bi-weekly basis, which is probably what we would need to do in order to potentially get this out in time. And so I think the question at this point is how do folks feel about meeting if we choose to meet monthly and maybe have a standing meeting that's the same day of the month each month, then we would be looking at definitely not getting something out this legislative session. Or we could push it and try to meet bi-weekly and see what we can do in the next few months here. What do people want to do?
I think the monthly meeting, I don't think that it's realistic that we're getting in the short session, especially because I don't think we're on any legislators. I mean, do we have somebody in the legislature that's keen on introducing the bill, so it's already lined up and raring to go? Because absent that and absent a finished product, I don't think we have any realistic shot legislatively to get heard. That's just been my experience over the years in the legislative process. I could be wrong, but otherwise, going to a monthly meeting, which I think is more conducive to lots of folks' schedules and hopefully makes sense. But I like the idea of picking a constant meeting point. I like that. Nobody else? Nobody?
I mean, this is a priority for my office. So I'm on board with bi-weekly meetings if we can get it. Jessica, I don't know when the deadline is for a full bill to go to the legislature, but I'm hoping maybe we could at least get a judiciary placeholder bill for this. I know at least one issue that will be addressed by this bill is going to be taken up by the Court of Appeals here soon. So
I can speak to the deadlines a little bit. The request deadline is in November, and then we're returning drafts in January. The issue is that all members, including committees, have really strict bill limits. I think it's 2 per member and 3 per committee. So it would be convincing a member or a committee to use one of their bills on this. And even if we did a placeholder, which would be returned in January, we would need to have the complete bill like ready to amend into the placeholder immediately, because as we all know, the short session moves very quickly. So we would have to have this completely finished by the end of December, realistically.
I see we're getting comments in the chat too, so maybe just so we can end today's meeting, if you have additional feedback beyond what you've been able to share here about the meeting schedule, let Kristen know. It does seem like we would be pushing it to get into the short session. It also seems like monthly meetings are good as long as, especially if we can have a fixed date, and Krista and Sandy and I can work on that. So perhaps we'll head in that direction, but also try to, continue our momentum. We're getting good feedback. We have things to follow up on, and it's important that we keep moving on these issues. So, that said, we will be in touch about a next meeting date, and we look forward to receiving the sample forms. And next time we will be talking about something that is an issue throughout these statutes is how do we identify who the notice should be served on, particularly in criminal cases, particularly because there can be a variety of entities that are the prosecution entities. So think about that for our next meeting. And until then, I hope you all take good care. Thank you.
Thank you.